All right. Good evening, everyone. Today is Thursday, April 6th. We are on voting list number 26. We are going to start off with Shamari with House Bill 207. If you could just explain the background as to why we're reconsidering this vote.
A bit of a mix-up, a drafting error. The House had actually a different version. I thought it was the same, but there was a one-word difference in 207, and that dealt with bodily injury. The Senate version said just injury generally, and the House version said bodily injury. Just bodily injury. And so I just wanted to bring that to the committee's attention, that the two versions were not identical.
So
we can leave the House version as is, and then I'm told by counsel over on the House side that they would concur.
So
they would amend the Senate version.
Got it.
Because we have the House version.
What was the vote on this? Does this bill pass unanimously? Did the Senate bill pass unanimously? Just because the motion would be to just run the House bill clean, but
it was 35-11. 9-2. It's different. Yes.
I literally just asked the same question. So it just, I know. Are you me? I'm you.
Senate says Part B on page 2, any provision in the contract or agreement relating to the use of a recreational facility that purports to release the recreational facility from limit, indemnify, or hold harmless the recreational facility against liability for injury caused by resulting from the negligence or other wrongful act of the recreational facility, and so on. So this House version says liability for bodily injury.
So just for clarification, what is the legal significance for the difference between injury and
so
bodily injury?
Theoretically, you could get other kinds of injuries, mental anguish. I don't know how you would get that at a gym, but
hey, you haven't been to my gym. All right. That was a bad joke. All right.
So injury could encompass more types of injury than just bodily injury. So emotional distress. The one we passed yesterday or 2 days ago has bodily.
So let's just keep.
I think that could be considered a substantive change. They weren't technically identical.
So we're just okay. So with the understanding that it's bodily injury, we're going to reconsider it because there is a substantive difference. Correct.
Are they going to pass the Senate bill?
Well,
they have to amend the Senate bill to what we're doing here in the House, in the Senate, the House bill. That's my understanding. No, I think they're going to conform the two.
I mean, the Senate bill will kick back. We will
Concur and then send it. All right, so the motion's for favorable. It's been seconded. Is everyone okay being recorded in the affirmative or the same as before? Okay. Senator James down, and then I think there's one other vote down. Do you want to be recorded in the same manner, or is it so? Okay.
Yes.
Who is no? Who else is no? Senator James.
It should be pretty easy for.
So everyone's going to. Okay, so just Senator James is down. That's it. Okay.
Oh.
Okay. Got it. Okay. So House Bill 207 passes 10-1. All right. So we're now going to move on to concur, not concurs. Can I see this one, Dave?
Do you want to read?
Oh, yes, thank you very much. Senate Bill 98. Which council is that? All right, Shamari, go ahead.
So Senate Bill or House Bill 98, the cross file was Senate Bill 403. And when this committee voted Senate Bill 403, we did not conform 403 to the House who amended the bill. And so the House has now conformed the Senate bill to their version of the House bill with the amendments. So the version, we passed Senate Bill 403 clean. And the amendments did a couple things. One, it struck the portion of the bill or the provision that exempted detached units from including a description of the common elements in the declaration. And it required owners of detached units of a condominium to carry homeowners insurance coverage on the entirety of their unit. Yes.
Discussion. All right, let's do not concur. I'll run them. Want to concur or not concur? What do you want to do?
Senator West, you had mentioned on the floor about conference committee for this bill. You had mentioned on the floor.
Yeah.
When it was on.
So let's say the motion that carries. Hold on 1 second. So it's been second. Is everyone okay not concurring with force conference? All right, fight.
This is one of the little tiny changes in the conference committee will be over in 15 seconds.
Potentially.
Everybody will say fine.
Nothing's ever.
Yeah.
All right, it sounds like you're the chair of the conference committee, but all right. All right, so we're not concur. Everyone's okay. Everyone's okay voting in the affirmative, not to concur. Okay, excellent. All right, so not concur. Everyone, so conference committee is going to be Senator West. Senator James, okay, and Senator Kelly. Awesome. There you go. All right. Now we will go on to Senate Bill 173. Who has that? I don't have, do we have council on here? Or House Bill 17, Senate Bill 173. All right, actually. All right, here we go. These are concur, not concur. So I'll give you your House counterpart. Give me a second. All right, so since we'll go with Josh, since you're here, we'll go with Senate Bill 383.
Senate Bill 383, as passed by the Senate, authorizes a court in a child custody proceeding to order child abduction prevention measures and establishes related procedures. The House amendments conform the bill to the House cross-file by making a couple of clarifying changes. The committee, and I believe the Senate as a whole, has already passed the House bill clean. There's a change in the terminology regarding the next business day. And then there was a reference added to the courts of this state honoring warrants of another state. Correct. We would conform or concur, sorry.
Do you want to make the motion? All right, so motions to concur. Everyone's okay being recorded in the affirmative to concur? All right, excellent. All right, Josh, do you have anything else on this list? Let's do it that way. It's also a Senate bill. Senate Bill 653. Go ahead, Josh.
So as passed by the Senate, Senate Bill 653 provides that for provisions governing child in need of assistance proceedings, the use of cannabis by a parent or another individual does not constitute neglect unless the use causes harm to the child or creates a substantial risk of harm to the child. The House amendments conform the bill to the version of the House cross file that the Senate has already passed. by moving the effective date up to July 1, 2023. Yeah, so I'll recommend concurring.
All right. Motions to concur has been seconded. Is everyone okay being recorded in the affirmative? Okay, excellent. Josh, do you have anything else? Shamar, do you have anything else? What do you have?
Seven.
797.
All right, go ahead.
This was the task force on preventing elder abuse. All the House added to the Senate version was 2 more members to the task force from the Maryland State Police and the Maryland Healthcare Commission.
Motions to concur is it's been seconded. Is everyone okay being recorded in the affirmative? All right, excellent.
And so
All right,
we
Shamar, do
also,
you,
that's also, we haven't voted House Bill 1191, the cross file.
House Bill 1191?
Yep.
All right. It is on our list. We'll just bring it up right now. It should be, it's now in the same posture as what we just concurred with. So most for a favorable. Second, everyone's okay with being recorded in the affirmative? Excellent.
Senate Bill 194. And so we already passed House Bill 118, the cross file unanimously. So for consistency, we should concur. Yes. Yes. It was a clarifying change to the form on the SDAT website, just to make the form standardized as opposed to a form. This was.
Motion concurred, it's been seconded. Is everyone okay being recorded in the affirmative? Excellent. Shamar, do you have anything else?
Senate Bill 277. So the House amended Senate Bill 277 with uncodified language to allow, at the request of the judiciary, to allow them to reallocate funding. So I'll just read the uncodified language. Notwithstanding any other provision of law on or before June 30th, 2023, the judiciary may transfer up to 12 million of the fiscal year 2023 general fund appropriation for the judiciary to the Circuit Court Real Property Records Improvement Fund established under 13602 of the Courts and Judicial Proceedings article. Notwithstanding section 7302 of the State Finance and Procurement article or any other provision of law, any amount transferred under subsection A of the section may not revert to the general fund of the state.
Defer to the sponsor. It's Senator McKay, right? Is that your bill? Yeah.
That's fine.
Excellent. So motion is to concur. Is there a second? Everyone's okay with it? Everyone's okay being recorded in the affirmative? All right. Senator Washington, do you have a question? Okay, all right.
Senate Bill 535. This is the service dog, Senator James bill.
You screwed it up, we're gonna agree with it for now. We'll fix it later, we'll fix it later. That's not what no.
So, give me 1 second. So, the House changed the definition of the service dog. So if you look on page 2 of the bill, we had said service dog means a dog that is individually trained to assist an individual who is blind or has low vision with navigation and other tasks. or alert an individual who is deaf or hard of hearing to the presence of people and sounds. And so those last two paragraphs were deleted and replaced with service dog means a dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability. Service dogs did not include a dog that, as a result of the animal's presence, is meant to deter crime or provides only emotional support, well-being, comfort, or companionship to an individual.
Motion is to concur. All right, so it's been seconded. Is everyone okay being recorded in there?
So there's one more part. So the last page of the bill, under Part D, an individual with a disability who obtains or retains a service dog as provided in subsection B6 of this section may not be required to pay an additional rent or fee for the individual service dog or former service dog, and may keep the individual former service dog in the dwelling for the life of the service dog after its retirement from service. And Part 4, it was added, shall be liable for any damage done to the premises by the individual service dog or former service dog. So essentially that element or that amendment just clarifies that former service dogs as well as current service dogs are protected under the bill.
All right, so the motion's the same. Senator James, I see you're okay. Okay. Everyone's okay being recorded in the affirmative for the concurrence. All right, yes, passes unanimously.
Senate Bill 191. So the cross-file House Bill 431, this was increasing from 4 to 5 the number of full-time assistant sheriffs provided to the sheriff of Prince George's County. House Bill 433, we amended and it was passed unanimously on the Senate floor. So recommendation is to concur to be consistent with that.
It's moved and seconded. Everyone's okay being recorded in the affirmative? Excellent.
Senate Bill 579. Yeah. So Senate Bill 579, can you come back to me and just pull up
Absolutely.
the bill?
We'll go to Jamie then. Which one you want to do?
Senate Bill 173. So Senate Bill 173, this is the automatic expungement clarifications. The House amendments put the Senate version into the same posture as the House bill, which is currently passed both chambers. So you would concur.
All right, Senator Walsh-Recker just want to speak on it and then we'll.
Nope, I agree. Just wanted to confirm.
Excellent. So the motion's for concurrence. It's been seconded. Is everyone okay being recorded in the affirmative? Excellent. Okay, Jamie, do you have anything else?
I do. Senate Bill 487. This is criminal procedure violation of pretrial or post-trial condition by an incarcerated person. This is the prohibition on victim contact. This also puts the Senate version into the same posture as the House bill, which is HB 411, which this committee voted out and is returned passed. So the motion would be to concur.
Motion's been to concur. It's been seconded. Is everyone okay being recorded in the affirmative to concur? Excellent. Anything else?
That's it.
All right. Shamari, when you have, if not, we'll go on a list for a couple votes and then we can come back to you, Shamari. No pressure. You ready to go? Come back. I got it. All right. Go to House Bill 1194.
House Bill 1194 prohibits a person from parking certain vehicles in the town of Sharpsburg and Washington counties. The bill does not apply if the parking of the vehicle is essential to its immediate use. And it does not apply to specified Class A, passenger, or Class E truck vehicles.
The one senator from the delegation is saying he wants it, so I think we're gonna move this bill. It's motion for favorable has been seconded. All right, is everyone okay being recorded in the affirmative? All right.
I'm not joking.
All right, Josh, we'll stick with you for a little bit. HB 262.
House Bill 262 authorizes a police department that takes an abandoned vehicle into custody to notify any secured party electronically if that form of notice is agreed to by the police department, the tower, and the secured party in writing.
Motions for a favorable? It's been seconded. Is everyone okay being recorded in the affirmative? All right. Passes unanimously. All right, we're gonna go, Josh. Let's go to, did we, House Bill 416, because that has to go to Triple E. Are there amendments in that packet?
There are.
Yeah.
House Bill 416 requires the Department of Labor to set goals for the number of inmates in education programs, establish a tracking system for the number of inmates in education programs, establish a tracking system for the progress of inmates in programs, and adopt regulations to carry out the provisions. There is an amendment in your packet from the sponsor that is number 263-224/1. The main thing the amendment does is it limits the requirements of the bill to inmates who are in state correctional facilities. It also creates a prison education delivery reform commission. It moves the effective date of the bill to July 1. And there's also a letter in your packet from the Department of Labor, which indicates that they believe the amendment reduces the fiscal impact of the bill to under 200,000 for them.
Ooh, that's enthusiastic. Move the amendment. I'll enthusiastically say, so do I. It's a really good bill. Seconded the amendment. Now the bill's before you as amended. Motions for favorable. It's been seconded. Hey, really? All right.
I'd like to see it, 'cause I'm reading it. Hey, wow, now, I'm with it.
Okay, passes unanimously. All right, everyone's good. Excellent. So on to Triple E, yes, with amendment, pass unanimously with amendment. Let's go on. Josh, I'm gonna stick with you for a little bit, okay? Have we moved on to House Bill 250? Let's see that.
House Bill 250 authorizes the MVA to issue a disabled veteran registration plate to an individual who has at least 50% service-connected disabled as opposed to 100%.
We passed this unanimously before the Senate version. Isn't there a Senate cross law we passed? Oh, we didn't. Anyway, the motions for a favorable, I like this one. That's great.
Yeah, we did that this morning.
We're on House Bill 250. So is motion for favorable? Go ahead, and speak on it. Senator Folden, go ahead.
So disabled veterans registration plates would allow them to then have access to any of the handicap parking. Is that correct? As I understand it?
I would have to double check on that, but I believe so.
So I'm just asking because I'm somewhat familiar with this process and I know that there are some, I mean, I'm all about supporting veterans causes. I don't want to come across as though I'm not. I just want to be clear that a 50% threshold, while I think it's great to recognize them and be allowed to do that, it doesn't necessarily mean that they have a physical handicap. That would require them to park and take away spots from people that actually have physical limitations. So I think it's a pretty low threshold, but I'm just throwing that out there.
That's a fair point, and I'm actually not sure if you have the DAV, you get so we're looking into that right now.
Yeah,
Just one second.
Well, it would be the DV plates or the DAV plates. This says the disabled veteran. All right, I'll look here a little further. It's kind of I'm just saying it's kind of a low bar just from my own experiences with the VA. You got what? If I had your 10%, I'd be 100. Does the MVA, I guess what I'm asking is, does the MVA currently issue tags, handicap tags for someone that would have a mental handicap?
Let's hold this until tomorrow. We'll talk to Chrissy Nizer and we'll get
Yeah,
the.
that'd be
get the
great.
answers on that.
Thank you.
Let's do that. All right, we are going to go on to House Bill 219, and then we're going to jump up to House Bill 186 with Jamie, and then we're going to head on to the.
We already passed one.
No, we did. That's right. Sorry. No, it's all, you're right. You're right. It's fine. It's on to B and T though. Has it passed out of B and T yet?
We were the secondary.
Excellent. All right, House Bill 219.
House Bill 219 requires the St. Mary's County Board of County Commissioners to produce a report recommending and describing the areas of the county that the board considers appropriate for the operation of unregistered golf carts on public highways.
All right, so motions for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? Excellent. Excellent. All right, we're gonna go on to Shamari real quick. If we could do House Bill 151, do you have, I'll give you a second before we switch over to you. House Bill 151.
House Bill 151 requires a landlord to notify a residential tenant in writing prior to a rent increase. The bill also establishes reporting requirements for local jurisdictions that adopt local laws limiting rent increases under specified circumstances.
I have a really minor amendment, I believe, on page 3, strike out lines 18 through 20, which say this section does not affect or supersede any local law or ordinance that requires additional notice. Now, this already requires substantial notice, and I don't think we should authorize local counties to require additional notice above and beyond this. This is.
So, I mean, that's not insignificant, but let's keep talking. So good, Senator Kelly.
Just in this right now? Does anybody know any?
I don't believe so.
I
I would just say that it sounds like a preemption issue. I wouldn't consider it insignificant, so I would urge us not to do that, and let's have a floor at the state law, not a ceiling. That would be my opinion.
So we've passed all sorts of bills this year. Most of these bills are coming from the tenant point of view towards the landlords. We had one earlier that we worked out with House Bill 100, and it was very successful. It seems to me we ought to try to strike a balance. This bill, once again, is a bill from the tenant's point of view. And so authorizing local jurisdictions to take these very substantial notices and increase them and increase them and increase them is, I don't think, the right way to go. If we want to increase them, we should do it down the road, but not just throw it out to the counties to pass whatever kind of notice requirements they want.
So we have passed several things, which I have argued against, where we're doing these where I felt were significant notifications for towing notices and where you could take people's property earlier by electronic format. So I just want to be clear on this. So if I'm reading this, it says that the bills we've passed where we could take somebody's property by electronic notice, where we can tow their car and take their vehicle by electronic notice. But on this says that requires the tenant to accept notice. Does this allow that also for this to be an electronic notice, or that they're not allowed to accept the electronic delivery?
They can, under the bill, still
They can.
accept electronic delivery. Yes. The
Does it?
provision in the lease can't force them to accept it that way.
But that's what I'm saying. So this bill says they can't force them to accept the notification
By
by electronic delivery.
Right.
But we've passed legislation this year where we have allowed electronic notification to repossess someone's property or take their car. We literally just voted on one that we can do one about a vehicle. We can send electronic notification to take someone's vehicle in a tow proceedings. But we can't, by this bill, we can't have a landlord-tenant discussion by electronic delivery and accepting a notice of a rent increase.
What is this?
So
Well, you can opt in for that electronic
But
notice.
we're giving them
No,
an
not-
opt-out, but we didn't give an opt-out for the people that could lose their home or car.
I'm not sure which bill that was, but
We just voted on one. We just voted on one about the towing.
We don't want 51.
Yeah. I just want to, if I'm reading it wrong, please tell me. But when I look at it, I think that it's pretty clear to me that it says that they don't have to accept notice of a rent increase under electronic delivery, when that's a significant way for a landlord to be able to send and have the read receipt that shows that they were direct upon receiving that. Whereas some people will, for the mail system, will avoid having the part with the certified mail stamp on it. They won't take it.
well, you can not, some people don't have email addresses, so I think this is meant to address that.
But it doesn't,
And-
it doesn't make it like we're allowing them to opt out of it. Like everything we've passed is about that we're going to allow them to do electronic delivery, take their house, to take their car, to notify them of this. But we're not allowed to do electronic delivery to notify them of a rent increase in this bill. So again, no, it's not allowing it. It's allowing it to opt in, but they don't have to accept it.
It says on page 2, part B, a landlord shall notify a tenant in writing before increasing the tenant's rents. The notice required under paragraph 1 of this subsection shall be sent by first-class mail with a certificate of mailing, or if elected by the tenant, sent by electronic delivery in at least one.
But that's what I'm saying. If elected by the tenant, why are we allowing it to be, if it's elected by them? Why are everything else we've done without the receiving party being required to receive it that way. If you have it, why are we giving them the opportunity to remove themselves from it when it's a very much a modern day current process that is used through electronic delivery systems?
Right, and so I think the point is that some people wouldn't have email and wouldn't be able to receive notification,
Seniors and others, yeah.
or they don't, they don't have email.
But by
Somebody
reading this,
uses
it says if they accept, right? Or what's that?
If they prefer that, that method of notification, they have to, that's the point.
Okay. Okay. Thank you.
Let me just press my amendment a little bit more if I could. You know, the longer you require the landlord to give notice of a rent increase, the more you're going to force the landlord's hand. The closer to the date of the rent increase, the more unlikely it is the landlord will do a rent increase, because the landlord at that point knows what all the parameters are. The further in advance you require the landlord to do it, the more unknowns will transpire between the time the rent increase has to be given to the tenant, and the more likely it is the landlord will want to protect himself from the vagaries of the future economics by announcing a rent increase. So you all, I think you're going to be helping the tenants by allowing local communities to say, no, 90 days is not enough. We're going to require 6 months or 9 months. The more you do that, the more likely it is the landlord's going to protect itself by announcing a rent increase, because the landlord doesn't know what's going to happen in the intervening period of time.
Sure. Do you know what is the law for the renewal? Like how much notice does a landlord need to give you if they're not going to renew your lease?
So this bill mirrors those exact notice requirements. And so for tenancies more than 1 week, but not more than 1 month, at least 60 days for tenancies for a term of more than 1 month, at least 90 days in advance. And for tenancies for a term of 1 week or less, at least 7 days in advance of the rent increase if the parties have a written lease, or at least 21 days in advance. And so those are the exact same notice to quit notice requirements under 8402 of the property article.
I got one question. I see a lot of landlord tenant leases where you have an automatic rent increase, it'd be like 3% or 5%. Does this affect that in any way? I mean, it doesn't prohibit it, right? Or
So
does it? I mean, you put it in the lease, you put it, it's in the lease and it's already existing that the landlord, and this is
there may be local rules about amount of rent increases, but this bill should not affect that if that's what's agreed to between the parties.
okay. All right. I second it.
Repeat your amendment, please. It's to strike the lines on.
It's very simple. It is simple.
It's 18, 19, and 20 on page 3 of the bill.
All right, so the vote for favorable, it's been seconded. We'll run roll call on the amendment. On the amendment.
No.
On the amendment.
Nope.
Yes. So
Yes.
Yes.
no.
No.
Yay.
Senator Carter,
No.
Senator Smith.
No on the amendment. All right, the amendment fails. 7-4. All right, now the bill's before you. Motions for favorable. It's been seconded. We're gonna do another roll call. All right, give me a second, I know.
Yes.
Yes.
No.
Yes. No.
No.
Yes.
Yes.
Nay.
Senator Carter,
Yes.
Senator Smith.
Yes,
That's Kelly's.
got it. So the bill passes 7-4. All right, with no amendments, actually. So, all right, now we are gonna go on to House Bill 824. We're gonna have council explain it.
So House Bill 824, this is the firearms bill that the committee heard yesterday. I guess instead of just doing a quick review of the synopsis, would it be more helpful just to go right into the First Amendment that
Yeah, I mean, is everyone familiar with the bill? Yeah, do you want to run through real quick? All right, just top down and then we'll.
So the bill is, it comes over to the Senate, modifies and expands first an existing prohibition relating to the possession of a regulated firearm. It also modifies and expands an existing prohibition relating to access to a firearm by an unsupervised child. And the requirements and procedures relating to the issuance and renewal of a permit to carry, wear, and transport a handgun, otherwise known as a handgun permit. The bill also increases the maximum handgun permit fees. Additionally, the bill requires that the Deputy Secretary for Public Health Services develop a youth suicide prevention and firearm safe storage guide by January 1st, 2024. Among other things, MDH must post the guide on its website and make an electronic version of the guide available to families, health and social services providers, and other interested entities as specified in the bill. And that is the 10,000-foot overview of the bill as it comes to the Senate. There are several amendments in your voting packet. In fact, just earlier in the voting session, I think a few more were passed out to you. Going off of the amendments in order, let's start with Mr. Chair. Could we start with 463-427/1? Again, that's amendment for HB 824. The amendment number is 463-427/1. That should be in the voting packet that was with you this morning. Sure, the amendment number is amendment number 463-427/1. Sure. I'm just looking around to see if everybody's got it. So, going off of the reprint of the amendment in order, the first thing you'll notice is on page 2 and 3 of the reprint, it strikes that language that I had mentioned about child access prevention. So that would no longer be in the bill. Moving through, it does add language immediately below that on page 3. This is page 3 of the reprint. You'll see italicized language with existing code for 4203 of the criminal law article. If you scan down to nearly the bottom of that italicized text, you'll see that the penalty for wearing, carrying, or transporting a handgun is increased from a maximum penalty of 3 years, which is current law, to 5 years, which would be new law.
Yeah, I'll get a jump.
Moving forward, makes changes to prohibited possession of a firearm under 5133 of the public safety article. These changes pertain to prohibiting a person from possessing a regulated firearm if they are on supervised probation for specified events. That being a conviction of a crime punishable by imprisonment for 1 year or more, violation of specified DUI, DWI offenses, or for violating a protective order under 4509 of the family law article.
It's after page 3. It's unmarked page.
Oh, yeah.
Oh, but just finish up the amendment and then, so just the one technical thing is, so a couple of things here that are being adopted in this amendment are, we're gonna ponder taking out in a subsequent amendment. So it's a little bit confusing, but this is a big amendment that was drafted before some of the subsequent amendments. So if you're just following along, let him finish describing the amendment. Let's adopt it so we can work off of one document. And then we've got a couple subsequent amendments that are gonna take and add things. So for instance, the language that's here on unmarked page 4, some of that's changing. So just want to make sure, just let him finish describing it and then we'll go forward. That page where you'll see the struck out language that says has been convicted of a second or subsequent violation of section 4-104.
Thank you. So that language with the firearm prohibitors for violators of the safe storage law, that's coming out of the prohibited person statute. Moving forward, that is the prohibition on leaving or storing a loaded firearm in a place where the person knew or should have known that a child.
So all that,
under current law,
all the safe storage stuff is now in a vehicle that's now in the house. So that's all being struck out.
If you move forward to page 7 of the reprint, there is language coming out at line 9, and that also pertains to a 5133 prohibitor for safe storage that would have put a 5-year moratorium on possessing a regulated firearm after a safe storage violation. That's coming out of this bill. At the bottom of page 7, you see the fee increases that are part of the bill as it comes to the Senate. If you go to the next page, we have no new changes, but let's see, page 9. Right, but that's as the bill comes to the Senate, that's already in the bill. The next new language for the amendment is on page 10 of the reprint. This adopts language that is evidently identical to what the Senate had passed in SB 1 relating to the firearms training requirements. So that includes the existing language, but also language on classroom instruction and the subjects that would need to be covered. Moving to page 11. This pertains to the conditions under which the secretary may not issue a handgun permit. So if you go to line 9 on page 11 of the reprint, it provides that the secretary may not issue a permit to a person if the person, one, has been convicted on or after October 1st, 2023 of a second or subsequent violation of the safe storage statute, that's 4104, or has been convicted on or after October 1st, 2023 of that violation, if the violation resulted in the use of a loaded firearm by a minor causing death or serious bodily injury to the minor or another person. There's also a 5-year moratorium on being issued a handgun permit if after October 1st, 2023, the person's convicted of the safe storage violation. So that the new language that's going in there, just to make sure I'm clear about it, the new language that's going in there is to make it so that it's only prospective to conviction. So somebody who had already been convicted under that provision of the criminal article, the safe storage violation, would not be subject to this. It's moving forward that this applies to somebody. Moving forward, the next changes are on page 14. These apply to the reporting that Department of State Police would need to do regarding handgun permit issuance. The amendment takes the language from SB 1 as it passed the Senate on reporting. And I think that gets everything as far as the amendment.
All right, I'd like to move the amendments. We can work off of that for subsequent conversations. Since seconded. All right. Now the bill's before you as amended. Senator Weston, Senator McKay.
So
Is this, if I believe that some of the elements of this amendment are unconstitutional, would this be the appropriate time to raise that, or should we adopt the amendment and I'll raise it at the end when about the entire
I would
bill?
suggest that you raise it at the end because it's like, this is gonna be like an iterative process. So like every amendment that we entertain, you should probably look at the reprint of that.
Right.
Because some of this stuff is actually coming out in subsequent amendments. We're just gonna do this chapter by chapter.
All right.
Senator McKay and then Senator Carter.
Thank you. My question is for you, Jamie. When you were explaining the amendment, page 15 and 16, you explained what was coming out there? You went from 14 and then was that an reiteration of it?
Sure. So thank you for pointing that out, Senator McKay. So on page 15 and 16, the bill as it came to the Senate had provisions for the Youth Suicide Prevention Guide. That had actually ended up in Senate Bill, is it 858?
So
Which
that's why.
passed out. So that's coming out in this amendment.
Was I asleep then, or did you not explain that?
House.
Okay, thank you.
All right.
Thanks, Mr. Chair. I don't want to make anything more complicated, but just for clarification purposes, can you better explain the efficacy of why we're adopting the amendment to take things out, and are they going to be, and after that point, then we'll entertain other potential amendments?
Yeah, I mean, just because this is like the base layer and this was drafted before, it's got more of the components of change. And then some of the stuff that we discussed earlier, like your amendments and Senator Folden's amendments, kind of build on this. So this is just a base layer of what we should discuss.
Okay.
So let's go to when Senator Folden gets back from, do you want to go to Senator Carter's amendment? Sure.
But there is another amendment in your voting packet, Amendment 873026. This was passed around, I believe, at the beginning of the voting session. It's Amendment 873026. And what the amendment would require is that, excuse me, that on or before October 1st, 2024, and each October 1st thereafter, the Department of State Police would need to report to the governor and General Assembly on the number of charges, convictions, and sentences for violations of 4203 of the criminal article and 5133D of the public safety article. So 4203 is the provision of law that the penalty was being affected at the beginning of the amendment that we just went over. So that's the 3-year penalty under existing, the where carry transport that's going to 5 years. And 5133D is the prohibition or the law that says that a person is prohibited from possessing a regulated firearm if the person is under 21 years old.
Senator Waldstreicher, and then, sorry, Senator Kelly was first. Sorry, Mike.
Mine is super duper quick. And it's another process question. I like the idea of building the layers. I just want to make sure I'm reading things correctly. So this packet with Senator Carter's amendment, which I also like, the reprint after that, is that as amended or? It's not. So that's the original. So we're referring to this reprint with that amendment on it. Got it. No, I appreciate it. I just needed the clarity as we went.
So I fully support the spirit of the amendment. I'm just not sure it's drawn to the right department. So wouldn't this information be in the possession of the Sentencing Commission, and wouldn't be that be the right reporting body as opposed to the state police, which wouldn't have access to this because it would be coming from the locals? And so I think the Sentencing Commission is the body that is aggregating that information, not the state police.
Yeah, I think that's better. It's either GoCap or Sentencing Commission has the information. All right. So then I'll ask counsel this. Would the proper thing to just, you can adopt this and you can just change that kind of by voice in line, just to, instead of MSP, you just have the Sentencing Commission?
Yeah.
Senator Carter, are you okay with that?
Yeah.
Go ahead. Go ahead. Yep. Senator Carter, go ahead.
Is there any need for me to explain why I think this is important? Or do you good? No, I don't have, no, I don't have to. If people are good with it, but if anybody questions like why we need it.
I think you're good.
Okay.
All right. So then the motions for favorable on the amendment for reporting, we're gonna have Dr. Sule and the Sentencing Commission do it. Is that okay? Is everyone okay being recorded? Okay, excellent. All right, Senator Folden, we've adopted the amendments. Senator Folden, we're gonna, Jamie's gonna outline your proposed amendments. And then I'm gonna kick it over to you to just explain, and then we'll walk down the other 5 proposed amendments. So Jamie, go ahead, and then Senator Folden. It's all, yeah, so.
Well,
No,
so it's a different one.
That's a different one.
So every person that registers for a firearm, they have to give their email. And those emails are collected. That's how you're responded, or that's how the state police reaches out to you within 7 days to notify you that you are, as they say, not disqualified. So these emails are all compiled. We do not currently notify any legal concealed carry gun owners of any changes in law, and I think it's important that we have access to all these notification vehicles, i.e. emails, to notify them. And we can then, at the end of each, I believe the specific amendment was that within 45 days of the close of each session, that the state police shall do a distribution to all registered gun owners of any changes relating to the law surrounding gun ownership, possession, and the like. The other component of it is, because the laws are implemented at various times, depending on if it's July 1, October 1, that within the 30 days prior to the implementation, or what was the word we were using, Chairman? Effective date, 30 days prior to the effective date, that they would then send out the specific narrative surrounding the law that is forthcoming within that month. And I think this is just a good, responsible notification process. And it's important that people understand and know what their rights are, that the legal processes and what they can and can't do.
No, it's interesting. So this, initially earlier in the session, Senator Washington had brought this up and conceived this idea because we were talking about notification about when we were entertaining SB1. We unfortunately were unable. We didn't do it.
Right.
So I want to thank Senator Washington for bringing this up, and then you
Yes.
guys working together on the concept.
Absolutely.
And I know that Senator Washington got another amendment as well, but I think this is a great idea. And we checked with MSP, and they said that they could do this with
nominal cost.
Nominal
Yes.
cost. So I think since Washington's the data guy, it's a good, I think it's a good
It's a
amendment.
great joint amendment.
Yeah. So I'd you are president. Right. Okay. All right. Yeah, it's like, you don't want to jam people up. So that was good, Senator McVeigh. I'll take that. All right. All right.
Basically what it'll do.
Yeah, go ahead.
Okay. So just the concept amendment will be that MSP needs to push an email out on 2 occasions every year to specified individuals, those being people that MSP has their email address in connection either with a firearm registration or a purchase or transfer. So they're the recipient of a purchase or transfer and this is just the concept, so the language may be different, but that person filled out a 77R or some other form, and that's why MSP has their email address. So they will do that on 2 occasions. The first occasion will be 45 days after sine die of each year, and the second time will be 30 days before the effective date of a piece of legislation affecting gun laws, to notify the person about the changes in the law. That doesn't account for emergency bills. Do you want to say, like, except for emergency bills? So an emergency bill would go into effect as soon as so for an emergency bill as soon as possible, practicable.
Practicable, since we argued over that word.
Okay.
Is the word, yeah.
It's like Sesame Street.
It's the word.
All right. So motions were favorable. Sorry, Senator Kelly, go ahead.
Clarifying question. I love the amendment. I think it's great and it's good government. But when Jamie did the concept, he said, any gun laws, are we talking about any gun laws or gun laws that directly affect those folks who have these? Like, there's a difference, right? It's not 100% overlap.
I think it would be important that any gun law, I mean, it's a simple narrative of the bill sent out so that they understand it. So I would say any gun law or any law affecting gun ownership and
It's not as arduous as you think, because they're just gonna pull from the.
No, it's not about arduousness.
No,
It's,
I
yeah,
hear what you're saying.
it's a policy question for me.
Yeah. All right. Are you okay? All right, so the motions for favorable with the amendment, is everyone okay with being recorded in the affirmative? Excellent, all right. Next one.
Clarify 5133 that it does not apply to
So this is
PBJ.
you, Senator Carter. The P-
Sure.
Uh, all right, go ahead, Jamie.
Is that okay? So the next concept amendment is to clarify on the page after page 3 of the reprint, page, the next page that's not page 4. So right, going off of reprint for if you're looking at amendment 463, 427, that's the first amendment that the JPR adopted on the bill. So that'll just be the reprint that we work off of for the remainder here. So it's 463, 427.
Well, just to work off the reprint for the.
Right. So if you turn. What's that? Right. Well, these are concept amendments that I'm reading off, so we'll just have to sort of plug in the reprint where this is going. So if you turn to page 3 of the
We're
reprint,
building while we're flying, okay?
if you turn to page 3 of the reprint, and then look at the next page where it says subsection B at the top. So like the line 19 says subsection B. You've got language below. This is the prohibitor. So a person who may not possess a regulated firearm, if they are on supervised probation for any of those 3 things that's below it. There was concern raised at the bill hearing that in Roman 2 and I suppose in Roman 3, this could be construed to apply to probations before judgment. So instances where in those situations there was no actual conviction, but a person still ended up in supervised probation. So the judge found them guilty and then entered probation before judgment. So the proposed clarifying amendment is sort of twofold. We're going to clarify that it only applies to convictions for any of these 3 things. And then it would also have specific clarifying language that specifically says that the prohibition does not apply to probation before judgment.
And
We're gonna strike those violations, right?
Right, so violation will change to conviction, and
Right.
we'll need to play with the language in drafting a little bit, but
Perfect. Yep.
violation will
Yeah, that was the,
probably not be struck, but it will say conviction for. at
yeah, that's
least.
the important thing. Yeah, thank you.
Not touching anything with the protector. I guess you don't need to say anything about that. Because they're gonna see it on the page, and if they see it, I don't want to. All right, so the motions were favorable on that amendment. Is everyone okay? I think I'm okay offering it, fine. I do Senator Carter, but yeah. Because the Carter amendment, the Carter.
So the last concept amendment we have, just going off of the reprint, is going to be on page 7 of the reprint, and those are the fees and the fees. So at the bottom of page 7 and into page 8, there's a suggestion. I'm not sure for which fees, but I would guess it's only for the first two. The fee that the new language would say is 150 and 100, to knock those down by $25 in each instance. Is that
That's right.
accurate?
So either
You know, the concern that PBJs are supposed to, the fees. That's Folden's, the fees, but I think that the slight lowering is good because of the fact that we know that we're going to have an enormous enhancement of the training cost. So makes sense.
I just think that it's reasonable to try to knock it down a little bit, and the training cost is expensive, and the cost of the concealed carry and the process involved, and that is not, and as we pointed out yesterday, that it's not supposed to be a revenue generator. So I think this keeps it at almost that balance of being cost neutral. So, thank you.
I can tell I'm going to be outvoted here, but just for the record, I don't think that I think the numbers that the Chairman Clippinger gave us, really justified the fees. I wrote them down in the hearing because they really shocked me. So I think the fees were justified where they are, and I don't think we're even going to be close to being a revenue generator, even with these new fees. So I'm going to be a no on the amendment, although I understand the place where it's coming from, and I feel like y'all when I made you pay for abortions. So you win.
no, it's a fair point. I mean, I remember he said that they hadn't raised the fees since 1993. So Senator Washington and Senator West.
Thank you. I agree with everything my colleague just said. Thank you. And I am going to vote no on this amendment on for Ariana that Senator Kelly mentioned. For all those reasons, I would be voting no.
So I'm trying to reduce the number of instances in this bill where the bill is unconstitutional, where it will be challenged for being unconstitutional and probably will be found unconstitutional. Mark Pennick is the smartest guy I ever run into in his own specialty area of law, and he knows the Second Amendment backwards and forwards. He says the standard is not the entire section of the state bureaucracy which deals with gun registration, but merely the section which would cover these particular registration fees. And he was quite, Luke talked about the whole area and how expensive it is for the state to administer gun regulation, and how these fees hardly cover begin to cover the cost. Mark said that the courts have held that the relevant standard is how much does it cost to handle these particular license permits, the issuance of the permits. And he said, based on the information he has, that the fees already totally cover the cost of the permits. So anything additional would be ruled unconstitutional by the courts. That being the case, I think reducing the increase is only prudent. And you may induce Mark, who is certainly going to file a lawsuit against this, induce him not to include this as one of the counts in the lawsuit. So.
No, I agree with what you're saying. I mean, I think you're right, and since Bruin has come down, we even learned today, and I've been citing 100,000, but since Bruin's come down, they've issued over 120,000 new permits. And, that's significant. They've been using overtime to plug the holes. This is not meant to be a revenue generator. And so I'm going to support the amendment for that reason. And also because we have made some significant enhancements for the training, some long overdue and significant and much needed enhancements for training. So, which cost money. And so I'm fine with it. I completely understand where Senator Washington and Senator Kelly are coming from. So I get it, but I'm going to vote for the amendment. And so I suspect we're going to do a roll call on this amendment. So yeah, we're just knocking it down $25 each one. Yeah.
So 125 for each and 75.
Yeah. Yeah. All right. So Senator James is up, and we'll roll the amendment.
Wanted clarification because my memory was jogged by what Senator West said, and I also looked at that. But I don't know whether we got any testimony or if we have any information for us about whether we know what the costs are for just the permitting. And whether the fees that are in the bill now have a nexus to it, or was there any attempt to relate fees, increased fees to the actual cost of the permitting? Do we have anything, like any testimony, any data from the state police on this bill? Because that could guide us some on what the fee should be. Well,
Great question. That's a great
you
question.
could probably get it between now and tomorrow,
I think it's a great question.
because
No, I mean, I think the chairman said, I mean, I talked about this before on Tuesday morning, that it was like, there's a $10 million gap and that the current proposed fees would potentially generate 8 million is what was cited. So is there a direct nexus in terms of covering the, I don't know the answer to that specific
The
question.
gap was because of just the fee, or the gap was something else. Could we find out maybe by tomorrow, maybe? Might help us.
Yeah.
Some I'd like
I'm
to
actually,
know.
I'll look into that.
Let's
I
just
promise you. I'll
find
do that.
out. Thank you, Mr. Chairman.
All right, so back on the amendment. So motions for a favorable, we're gonna do a roll call.
150 to 125 and 100 to 75.
Yeah, yep.
Vice Chair Waldstreicher,
Yes, on the amendment.
Senator Sidnor,
Yes.
Senator West,
Yes.
Senator Buse,
love Fruit Loops. Yes.
Senator Folden,
Yes.
Senator James,
Yes.
Senator Washington,
No on the amendment.
Senator Kelly,
No on the amendment, thank you.
Senator McKay,
No on the amendment, no on the bill, no to this meeting, no.
so no on the amendment. Okay, Senator
Yes.
Carter. Chairman Smith,
Yes.
Senator Fulton's amendment.
So
So this is amendment 333222. How that numbering worked out, I don't know, but it's amendment 333222. So
it's for 824.
Oh, yeah, I had it.
So this amendment would require the Office of the Attorney General to develop, publish, update, and distribute to all state certified firearms instructors as needed a curriculum of instruction for the following: state and federal firearms laws, state self-defense law and applicable case law, including justifiable use of force or deadly force, the proportional use of force in self-defense, and conflict de-escalation and resolution. And the Deputy Secretary for Public Health Services would need to develop, publish, update, and distribute to all state certified firearms instructors as needed a curriculum of instruction for conflict de-escalation and resolution.
All right, Senator Folding must be on.
this amendment comes from, and it's going to be kind of commingled with the next one to give more clarity, but this amendment is important because a certain portion of the requirements that we are now requiring, being that of suicide prevention, anger management, and the like, conflict de-escalation is important. So I felt it was important that we include the mental health services people who have the ability, the knowledge to be able to help in conjunction with state police or the OAG, which as this says, but the next one will be with the state police, to establish a curriculum so that all firearms instructors, no matter where you go across the state, teach this same curriculum. If you go in Western Maryland, the Eastern Shore, Montgomery County, or anywhere else, the curriculum will be standard. And then that's how we succeed with the knowledge base that everyone is taught the same exact information. And I think that's important for responsible gun ownership. And if we're going to hold people accountable, that they're at least trained on these, and we're requiring them to be trained on it, that they're required or that they are trained appropriately. No, it's like it's 2 whole days.
Okay.
Yeah, no problem.
Yeah, thank you. I think it's a decent amendment. I wonder the question whether or not we need to, if this training, because we talked a little bit about some of these instructors showing YouTube videos and things like that to folks. I wonder if can the current training be virtual? It can be virtual training.
Oh, that's in person. Yeah. But the classroom component on like the existing subjects can be virtual.
Yeah, so my question is, I mean, if it's allowed to be virtual, you know, and there's a term for it, whether it's someone actually teaching you or doing it right in front of you versus them just playing a pre-recorded video for you virtually. And so I wondered, do we have anything in law that states that it has to be not just in person, but if it is virtual, then there has to be an actual instructor doing it there and they can't just show a video. It can't be pre-recorded.
Like you can't just show up to the course and sort of somebody hits play on the video and then goes out for a coffee and
it comes back
an hour later or something like
Right.
that. I'm not aware if there's anything to prohibit that from being the case as far as the instructors go. All the information I do have is that the instructors do have to be certified or licensed by Department of State Police. But as far as what their level of engagement needs to be with their classrooms, I don't think we have any information. We can find that out though.
Okay, thank you.
So Senator Muse, go ahead. And then I know
What you're talking about, they at least 12 years ago, you could go and purchase a gun and you just sit there in front of the screen, watch it, and then, you know, they say everything you need to do, and that was it. Everything was done. You did everything except shoot, because that wasn't a part of purchasing. And so now we're talking about right to carrying. So it would seem to me you would have to have gun training on at the range. So you got to be there to shoot and do that. But the part you're talking about, just the instructional part, for example, justifiable use of force or deadly force, et cetera, proportional use. Those are concepts and policies and lectures, and you can do that and then go do the other part, right? Or what do you think, Mr. Chair?
I want to be very clear. I mean, I understand what you're saying. You are not allowed to take, I don't know what class Jamie took, but in Maryland, you're not allowed to take this virtually. It is an in-person instruction because Q&A is important. So
Okay.
I don't know if you took an HQL or something of a lower, but for concealed carry, it's an in-person class.
Well, this was during COVID too.
There is no virtual training. It's in person.
The live fire part was in person at a range, but the classroom portion.
I'm just letting you know, I'm in direct contact with someone that is a certified firearm instructor across the state, someone who speaks here often, and they are saying absolutely you cannot do virtual.
Interesting. Okay. No, it was my impression that MSP had given a waiver during COVID.
Well, they may have given a waiver, but it's not
Yeah.
there now. I mean, there's a lot of waivers. So, I mean, that's during a national, pandemic or international pandemic, national state of emergency.
That's a good.
But the class itself, the requirements are in the state of Maryland, you must be in person and show the competency to be able to handle that. I mean,
Presently 16 hours,
yes,
presently 16 hours.
correct.
For this, you're going to maybe 24 hours. 2 days.
No, it's just going to be very succinct, compacted,
Okay.
and very deliberate in the manner in which it's taught. There's no room for, YouTube video here and there, just saying, okay, suicide prevention. It's important to know that guns can be used in suicide. And then that would literally check off a box. The important part of this is that they're educating new gun owners, new carriers of weapons of what the proper
Okay.
expectations are.
All right, so Jamie, go ahead real quick and then you'll go back to Sarah.
But I guess, was this all related to what Senator Washington had also asked about? Not only was if it needed to be virtual, but sort of the level of engagement, even if it is in person, which is that could they just hit a videotape, hit play on the videotape?
Yes, it requires an instructor to be there, the live instructor. So if they teach from something that's pre-recorded or that they've done, and then they speak about it, expound upon it, I don't know that you can prohibit that because it still allows for the dialogue, the Q&A, and all the explanation is there. If there's any information exchange that needs to happen, it's there. But it's an in-person, it's not something you can just hit on your desk virtually at home and then go cook your breakfast and lunch and just let it run. You actually have to be present. You have to be a part of the class.
Okay, well.
So it'd be so simple I'm looking at the bill. It says for initial application, a minimum of 16 hours of instruction by a qualified instructor. We could say for initial application, a minimum of 16 hours of in-person instruction by a live qualified handgun instructor.
Well, in
That would-
would be live, I hope. That might be conceived.
Yeah, no.
That was actually kind of funny. But look, all right, let's do this. Let's do Senator Fulton's amendment first, then we'll entertain Senator West's amendment.
I
All right.
move favor.
It's been seconded. Is everyone okay being recording the affirmative amendment? All right, great.
Okay.
Senator West, go ahead and can you on camera, please? Could you do that?
Yeah, I thought it was gonna happen. Okay, so it's on page 10 of the bill copy that we're working off of. It's just after line 18. It says the firearms training course required under this subsection A shall include 1, for an initial application, a minimum of 16 hours of instruction by a qualified handgun instructor. We just changed that to say for an initial application, a minimum of 16 hours of in-person instruction. We could include live or not as you choose. In person, I think should be sufficient. Yeah.
So the motion's been moved. It's been seconded. Is everyone okay being recorded in the affirmative? Excellent. Okay. This is the second time that's happened. We had another amendment that had it was actually in Jalen's law. It had the deputy secretary promulgating the instruction. We changed it in Jalen's law, I think, but why was it the deputy secretary and not the secretary or just the department? Can we just change it to the department of health? All right. Yeah. All right. Is everyone okay with changing that? All right, got it. All right, now Senator Folden, you have another amendment you'd like to us to turn it in.
And I guess just correct me if I'm wrong, but this amendment deals with the standardization of the training across the board. Any of the enumerated training standards that are required now, that there would have to be a curriculum established and distributed by the Maryland State Police, dealing with all these very, these important manners, but especially around the laws concerning what would create a violation, the self-defense, defense of others, defense of property, the safe storage. Everything under this would be covered with some type of standard training curriculum established by the state police to be distributed to all firearms instructors so that all receive the exact same training regardless of where they go for training in the state.
So
Senator, understanding of what you're asking for, and you tell me if it's correct. Basically, the amended bill contains a number of areas that need to be hit as far as training, as far as firearms laws, suicide prevention, conflict de-escalation, things of that nature. It sounds like the amendment would be that DSP, Department of State Police, would need to basically develop a standardized curriculum for each of those things and give that to the certified firearms instructors so that there's a uniformity to the coursework that they're doing for the initials and the renewals.
Some very important issues that isn't gone over as thoroughly from one instructor as it might be another. And then there's also, because there has been no guidance up to this point, there is a lot of liability that gets thrown back on these because they're being mandated to teach law, but they're not given any guidance.
So
that's wholly.
Does that sort of build off of the amendment that
It does.
you just
It
adopted?
absolutely does.
So we'd actually change that amendment to basically say DSP in consultation with OAG and the Maryland Department of Health shall develop a
Yes,
standardized.
That's where I was saying when we
Gotcha.
started that,
Okay.
that it would merge together.
Gotcha.
So just I love the idea. I just toss this out for discussion and the two items of concern. I think that the training has purposely been a little less prescriptive to avoid issues of liability. One. Two is how arduous is it going to be for the department? I just don't, I mean, I love the idea, but I just wanted to throw that out there just for discussion, like how arduous it's going to be.
I think in the consultation with the MSP and you've got the OAG, two of the primary, you got
Yeah.
the law enforcement roles in the community, and then you have the Department of Health involved in this. It provides direct, let's look at it like this. State police teach firearms. They teach it to their troopers when they in the academy. They do recurring training. It's important that the standardization be transitioned to a language that a civilian can comprehend and then pass it along to them so that they understand the consequences of actions with a firearm, as well as the importance of safe storage and these opportunities for de-escalation, creating space, all these things that are so important, we don't standardize. And that's a problem. With 120,000 permits going out or guns going out, that's a problem.
I agree. All right, Senator Washington.
But the Second Amendment, because I thought we were saying the OAG has to do it, but now we're saying the OAG with the Department of Health and yeah. Got it. Now, I guess my question would be, does the OAG, does he understand the intent of the amendment to be able to create a curriculum for something like this with these other agencies? And have they done that before where they created these types of?
I think it's easier to say
standards?
that the Maryland State Police in consultation with the Office of the Attorney General, not that we're requiring the OAG to craft it, but that the MSP in consultation with the OAG shall create this curriculum.
I think I like that version of it better, where the OAG doesn't necessarily create curriculum, but the Maryland State Department does.
I think you're right. And the way it was discussed in the hearing was that, every department has an attorney general nested within it. And it would be in consultation with that individual. Senator James.
I would just want to point out and think about the fact that we have a lot of different requirements here. Some really are asking for a description of the law. And I'm not sure we should be putting that on the state police. And quite frankly, there are no statutes for most of what we're asking for. So it's all common law. So I'm just saying that, to me, you have to sort of work. There'll be some of these requirements where the OAG should take the lead. There's some where the state police should be the leader in the crafting of the curriculum. And then I think anger management or de-escalation, I don't think the state police or the OAG are going to be.
That's where the department.
I know, I'm just finished. I'm just, the mental health department. So I don't know how much we want to get into the weeds or just say they have to work collaboratively on these three areas, but they're so distinct. Each of those three has an expertise in one, but not all. And that, I think we have to think about.
No, I
that.
think you're right. I mean, that's why we can't get too granular.
Right.
And it's in consultation with the attorney general. It's
Right.
in each department. So
Right.
I think we're in the right neighborhood, but Senator Washington, then we'll go to Senator Sidnor.
I hope it's my last piece on this amendment, but I think what would solve what Senator James was bringing up is a line that maybe that's all inclusive, that says something like not limited to, maybe to these to provide them with some flexibility.
Department of State Police in consultation with OAG, Maryland Department of Health, and any other appropriate. Oh, well, I think the idea was going to be, or my understanding was that it was going to basically be a catch-all to say anything required in the training needs to be part of that curriculum. So everything that's on there will be reflected in what's developed.
That's what.
That's the concept amendment, right? Right.
Yes. All right, so motions. Everyone okay? Everyone's okay being recorded in the affirmative? Excellent. All right. All right, the last just subject that we're going to discuss is the some of the exceptions, and there's one in particular. Senator Sidnor, if you want to talk about it, it's the uniform services piece. But if you want to speak to it, your concern, and we'll move on.
Sure. Just for clarity's sake, there was some discussion that came out talking. We were discussing people who were under 21 that may be in the armed services, and some confusion with the language that's on line 17 through 19. And my suggestion was just to strike that specific exclusion so that the language would read, subject to section C and D of this section, the secretary shall issue a permit within reasonable time to a person who the secretary finds is at least 21 years old, period.
I No, I don't know, I honestly don't know I get the armed services, I get the National Guard. But can you just develop your concern again with the uniform services? And that's like the whole thing. You want to do the whole thing? Oh, wow.
If you're, it's my understanding, if you're, say it again? No, what's your concern? Go ahead. I understand. What I'll say is, again, I think if you're in the services and you're active and stuff, you're not disqualified from carrying a weapon. Am I correct? So I mean,
On duty. You're on duty or going to or from duty.
so if you're a 19-year-old who you would qualify under this particular exception and wouldn't necessarily have to be, isn't that what we were talking about?
Well, there's two things in play that come to mind. So in general, somebody who is under 21 is prohibited from possessing a firearm under 5133 of the public safety article. That has an exception though for service members on duty or going to or from duty. Then 4203 of the criminal article, that's the prohibition on generally wearing, carrying, or transporting a firearm or a handgun, would require somebody to have a permit as one of its exceptions. Another one of its exceptions is a member of the armed forces who's either on duty or going to or from duty. So I don't know that a member of the armed forces, I don't think a member of the armed forces would be required to possess a wear carry permit in order to carry while on duty or going to or from duty.
And the underage portion of it?
So in this, it seems like the permit would be in addition to, would not require them to be on duty to get the permit, although I'm not sure how that sort of meshes with the general prohibition on being under 21 and in possession of a firearm or wearing, yeah, it would be that 5133. You're prohibited if you're under 21. I'm not sure how that would mesh if they're off duty.
Which was some of the confusion that I was talking about. So then if it was completely taken out, then it's a clear, bright line that you have to be 21.
So I'll just clarify, because I know maybe we spoke about it back. I may have caused more ambiguity than I meant, but so like for me, when I went in the military, I was 17. When I was 18, I was a military police officer. I carried a pistol. I was allowed, and then when we would go off post in times, whether I was overseas or in country, I still was allowed to carry it, even though I may have been underage by federal law, because I'm holding a position within the armed forces. So I think part of the guise of this was to make sure that we didn't inadvertently create where someone of like me who becomes an MP, because military police is more of a mechanized infantry, not a police like you may think of them, so that they don't get inadvertently charged with something, possessing what there is in the scope of their responsibilities. Where we were talking about the loophole in the back is that I believe, like Jamie and we were discussing it, I believe it does leave a little bit of ambiguity, because you can still take a class, but you're not allowed to carry off duty the same weapon that you would carry on duty.
So I'm looking at the
That's interesting.
5133
That's interesting.
exceptions right now, Senator.
Right. I'm sorry.
I said I'm looking at the 5133 exceptions right now, Senator. So for the under 21 person,
Yeah.
the next closest exception besides being on duty in the armed forces that I see would be current exception. This is making you no longer prohibited if you're under 21. A person who is required to possess a regulated firearm for employment and who holds a permit under subtitle 3 of this section. But
they can't do that under.
you wouldn't
21.
be off
You're not
required to
authorized
while you're off duty.
Under that,
Right.
Section 3, you're not authorized to get that
Right.
under the bigger guise of the article. Correct?
Uh,
So I guess what I'm saying is my only concern is that if we had it to where we're putting something in this, and I don't know if that's the right thing with what Senator's saying, was that we don't want to inadvertently create a conflict with federal law by someone who is allowed to carry it in the performance of their duties, but they're not allowed to carry that same gun off duty. I know, I'm just saying they couldn't, I mean, I understand what he's saying. I don't think this allows this to happen, but I do understand his concern that we want to be sure that it can't happen that, because you're a trained carrier of this on duty, you go home, you're obviously not allowed to buy it because you're not 21, even if you are a federal, it's issued. But if you go home and your dad has a service type weapon, a handgun, you're still a prohibited person by age. I think what the Senator Sidnor was trying to say is that we want to make sure we're not creating a loophole that same person isn't allowed to carry their father's handgun. Right? Is that what it is, sir? Yeah. So that they're not, and I don't think it does provide for that. I don't think it does, but that's why I'm deferring to your expertise. And I understand his concern but I just don't want to create something where we do that very thing. I hope I said it well enough for you. Perfect. Thank you.
So I think we should keep the bill as is. And I think it's important to accept the members of the armed forces, the National Guard and the Uniformed Services. And I'm pretty sure we do this in other sections of the code. We know that there are high training requirements for the wear and carry, but there are even further requirements for the armed forces. And that level of further training provides a sense of comfort that we can allow this exception, just as we do for police officers and others under this section. There are points at which someone who is a member of the armed services will have their service weapon and be not necessarily traveling to or from, but kind of sort of doing that. And this clarifies that they're okay, right? So if you're traveling to somewhere, but dropping off your child at, in the carpool line at your local school, if you remove this section, you criminalize that person traveling with their weapon, going through the carpool line at a school. We entrust the members of our armed services with our freedom and our lives, and we should trust them to have this exception under the law. I think it's necessary for the merits of the bill. I think the sponsor is well intended, but it could be accidentally, and he doesn't intend this at all, just to be clear, but could actually accidentally be perceived as kind of disrespectful to members of our armed forces. And we know that in Maryland, because of our proximity to bases and to the District of Columbia, we have a disproportionate number of citizens here in Maryland who fall within this class. And I think we should keep them. I think they should be protected. And I think it's important that the code reflect the respect that we offer and the training that they've received.
Excellent discussion. All right, Senator Carter, would you like to speak? If not, I'd like to make a motion on the bill itself.
Be angry. I don't agree with the Senator Vice Chair on that. I supported Senator Sidnor's. I didn't feel like it's necessary to have it here. They already have the exceptions in the law. And I do think keep having it here creates some potential ambiguity, especially if something wrong happens and then there's a belief that the person was exempted because they were in the military. But that being said, that's not what I really wanted to speak about. Before we vote on the bill, and I know I appreciate all the discussion we've had, I truly do. Sometimes with all of the work that we're doing, you don't always think of everything at the time. And so as we were sitting here discussing the expanded training that we're doing for legal gun owners who ostensibly, for the most part, based on data, are not often misusing or committing very many crimes in Maryland. But we've also increased penalties for people that are in illegal possession of the guns, which I remember when we had our first briefing at the beginning of session, and the state's attorney who initially brought this issue forward said, I am for giving people an opportunity. I'd entertain, the possibility of having someone be able to clear their record or dismiss it later. And so what I was thinking is, I think we should entertain an idea that someone that's convicted under this with the increased penalty also be given a pathway to sort of be trained and understand and learn about gun violence and anger management and conflict resolution. Like, why would we reserve all of the education and training for the one category and exempt the category of people that probably need it most? And so my suggestion is that, assuming people are convicted under this, they're either going to have a jail sentence. Usually, if they are convicted, they're going to have a hybrid sentence. They're going to have an incarceration period and a probation period. And so my suggestion or potential oral amendment is that for that period of probation, that they would be given those trainings or an option for those trainings and a pathway to potentially work their way into out of the conviction. Eventually, we don't allow any type of expungement under law, and I'm not suggesting that we should for the gun violations. However, we could possibly entertain, like if someone completed a 5-year sentence in a period of probation and engaged in all of these trainings, they'd then be eligible to apply for that and maybe work their way into legitimacy. So those are my thoughts. What do you think?
So I appreciate where you're going there, Senator Carter. And I mean, I'm just want to be clear because I think you summed it up at the end, but I want to be clear. So what we're saying is that there's a potential that someone that would be arrested or have this offense with the, I think did you say an illegal firearm or I don't remember.
They're convicted under the statute.
Yeah.
We've now increased the penalty.
So they just increased the penalties, but what I'm hearing you say, and I hope I'm hearing this right, is that the person through these trainings, these classes would be able to basically redeem themselves, show themselves, be in good compliance, it's good citizen within the law, that if they did that we're showing a path for them to be able to come back to legal gun ownership.
Potentially, and legal citizenship, like society, like all of the things that go along with that.
I mean,
Absolutely.
I'm okay with that. Thank you.
Thank
I
you.
like it.
So
I'd offer let's draft that. That's a very complex amendment. I'd ask you just draft it. But I'd like to move this bill. You draft it and we can entertain it on the floor, but I'd like to move the bill. Second, motions for favorable has been seconded. Senator West, you'd like to speak?
Yes.
On the bill, this is on the bill,
On the bill.
not the amendment.
Yeah, no, on the bill.
So we're off the amendment?
Off the amendment. The motion was for favorable on the bill, not the amendment. Favorable with amendments. I said drop that amendment for a floor amendment if you want to, Senator West.
Thank you. So those who were here when we considered Senate Bill 1, I think that there are one or two people who weren't here at the time. I'm looking at you, Senator Kelly, will recall that I spoke at length, both here and on the floor, about the unconstitutionality of what we passed. And bottom line, I swore that I would support the Constitution of the United States and the Maryland Constitution. And so I've sort of laid down my standard. I will not vote for a bill that I think is unconstitutional. I think this bill is unconstitutional in 3 respects, which I thought I would explain. And then if somebody cares to offer an amendment to cover these, I would feel comfortable voting for the bill. but not so long as these three problems still remain in the bill. Firstly, on page 3 of the copy of the bill we're working on, there's this section 4203. We increased the penalty from 3 to 5 years. I have no problem with that, but that exacerbates the underlying problem. Section 4203 provides that except as provided in subsection B, a person may not carry a handgun, period. So except for subsection B, you can't take your gun out of your house, which is totally contrary to Bruin. It is about as flagrantly violative of Bruin as I can imagine. I'm getting late, so you have to deal with my relative inability to speak as fluently as I do other times during the day. So, and if you look at B is a section that says you can carry it if you were such and such, or if you were such and such, or if you were such and such. It's almost like looking at a spider web. Everything that's not the skein of the spider web is open. And under section 4203, it means it's illegal to carry your gun unless you come within the skein of the spider web. If you fall in one of those open spaces, it's illegal to carry your gun. It is totally unconstitutional. And this bill, which increases the penalty from 3 to 5 years, only makes it more so. 3 years is bad enough. It's criminalizing constitutionally protected behavior. Increasing the penalty to 5 years makes it even more unconstitutional. So that's point number 1. Point number 2, I'm going to pass over the fees. I was going to talk about that, but I think we reduced the fees enough that I think you can make a credible argument that the fees as revised are not unconstitutional. But now we come on to page 8 of the bill, which says that secretary shall issue a permit to a person who the secretary finds A is at least 21 years old. Now, there are at least 3, perhaps 4 cases recently that have held, 3 of them under Bruin, 1 a case of the 4th Circuit Court of Appeals, which has direct authority over Maryland. Cases that start in the Maryland District Courts go to the 4th Circuit Court of Appeals on appeal, and then they go to the U.S. Supreme Court. So the 4th Circuit Court of Appeals governs the state of Maryland. 4 cases now. One is called McGraw, was decided last August 22nd. It struck down a ban on carry by 18-year-olds. Can't remember what state that was in. So another is called Beeler versus Long. That was in Tennessee. That also, that was decided this year, 2023, after Bruin, and it overturned the Tennessee ban on carry by 18 to 20-year-olds. Last week in Minnesota, the case of Worth versus Harrington was handed down, striking down a ban on carry by persons under 21. And then the 4th Circuit case I mentioned was the Hirschfeld decision. It was a pre-Bruin case, but it banned the sale of handguns. It struck down a ban on the sale of handguns to 18 to 20-year-olds as unconstitutional. So we have 4 directly relevant legal decisions holding that you cannot deny the right to own a handgun or carry a handgun to someone who's under 21, but over 18, but under 21. That's what this bill does. It's directly unconstitutional. And finally, if I can find the section, there it is. It's on page 10 of 17, which says that a right to carry or right to possess a handgun can be based on an investigation, can be denied to someone if has not exhibited a propensity for violence or instability. I don't think the word not should be there. Shouldn't it, Jamie, be has exhibited a propensity for violence or instability? I'm on page 10 of 17. I'm down at line 12. Oh, maybe, okay, maybe you can give a permit to someone who has not exhibited a propensity for violence or instability. The problem with that is that there are no objective criteria there. It has the same problem as the law of Maryland pre-Bruin, which said for cause, the state police could deny someone a right to carry a gun. And the state police had no standard for what was cause and had total discretion as to whether they denied someone a right to carry a handgun or not. Here, once again, there's no objective criteria. It's the court, the decider would make this decision based on pure discretion. And that's disallowed by Bruin. So I say it's getting late. No, I think it's Bruin. It's like the other name for a bear. So if we could get over these three problems, I could vote in favor of this bill. But as long as these problems exist, the bill's unconstitutional in my books, and I won't vote for it.
I hear you. Well, I appreciate that. Two of the issues you mentioned are in current statute, and one of the four cases you mentioned was in the Fourth Circuit in Richmond. So I get it. I understand what you're saying. And I've no doubt that current statute will be challenged and will end up in Richmond. But I understand. So there's been a motion for favorable. It's been seconded. We're going to do a roll call on the bill with amendments. Oh, sorry. I'm sorry. Senator McKay.
Thank you, Mr. Chairman. So my question is, I do believe that Senator West is correct. This is unconstitutional and will be found very quickly through the court system. But my understanding is that it requires the secretary to revoke a permit and finding that the holder does not meet the qualifications described. There's no mention on how the secretary is going to address the 120,000 citizens who already are currently permitted to carry a handgun, whose training does not meet the new requirements. And if this becomes law, will the Secretary of the State Police will be required to revoke all these existing permits of wear and carry? How does that get addressed?
So Senator, if you turn to the last page of the reprint that we were working off of.
Yes.
That's for amendment 463-427/1. On the last page, there's new language, and as you were talking about that, it stood out to me that I may have actually omitted mentioning that just by accident, but it is in the language. It says Section 2, and be it further enacted that the provisions of this act shall be construed to apply only to an initial application or renewal application for a permit to wear, carry, or transport a handgun that is submitted to the Secretary of State Police on or after the effective date of this act. The provisions of this act may not be construed to affect the requirements to maintain a permit to wear, carry, or transport a handgun that was issued by the Secretary of State Police before the effective date of this act until the permit is subject to renewal. So I think that uncodified provision addresses that issue that you mentioned about the law coming into effect. There's new training requirements. And then on the effective date, the existing wear carry permit holders no longer meet the new training requirements. So that's meant to address the applicability there, that they would not suddenly be subject to forfeiting their permits because there are new training requirements which they weren't trained on.
Which then starts the whole process over again with all of the fees and those type of things, which is going to make it. I mean, I'm not following that. So if they go through the new training and all that kind of stuff, they'll have to pay for all that?
Well, not until they're subject to renewal of their permits.
The answer is yes.
So the renewal will be fine.
So
Not another class. One of these classes are about $400.
Right.
So
So,
when you get your renewal, they'll have to pay another $400.
well, for the
Change the
8-hour renewal that they would already be required to take, it's just that this new 8-hour renewal at the time that they're required to renew, that 8-hour course that they're required to take in order to renew would need to meet these new requirements.
Okay, so it would be at the renewal rate,
Correct.
not at.
Whatever.
Whenever your renewal time is.
Right.
This
So
new
if-
training material will be incorporated in that.
If we're talking about the application fees paid to Department of State Police, those would become effective at on the effective date of the bill. So if, let's see, this is October 1st. So if on October 2nd, somebody makes an application either for an initial permit or a renewal permit, they would be subject to the rates in effect as of the effective date of the bill. For both the initial and the renewal.
Thank you.
Vice Chair Wildstriker,
Yes.
Senator Sidnor,
Yes.
Senator West,
No.
Senator Muse,
Yeah.
He's present.
Senator Folden,
He's on campus.
Senator James.
Before I vote, I just want to make a comment, which is in addition to what Senator West brought up, which is really frustrating for those of us that really care about the Constitution, but also greatly care about, you know, having a post-Bruin scheme in place. So it's very frustrating that 3 very easy fixes could better align this bill with the Constitution. I just have to say, I can't vote for this bill today because not calling anybody out. I'm tired, but around my staff told me at 3:45 I was on a work group and for this bill, and maybe they misunderstood that. Maybe it was something else, but all day I have been hanging around and waiting to meet, and I popped my head in several times, and I just feel like I was not brought up to speed, wasn't given a chance to hear the details of this. I think this is a big deal, and I think every committee member should have been afforded that. So for now, I have to vote no.
Senator Washington,
I am on campus in here and I vote yes.
Senator Kelly,
Yes.
Senator McKay,
I am going to be a nay, but I have to second what Senator James said. I was never afforded a chance to understand anything that was going on and sat here patiently. Thank you.
Senator Carter,
Yes.
Chairman Smith,
Yes, and understanding the constitutional issues, this is a post-Bruin, the case law is evolving every single day all across the country. So this is a fluid situation, and it's hard to tell what will be constitutional in 6 months, let alone in 2 weeks. So I understand the concerns and the difficulty. As for the personnel issues, that's on me. So for Senator James and for Senator McKay, that's on me. My apologies, trying to juggle 2 work groups in one day between cannabis and this. And so that's on me. That's my fault. So I take full responsibility for that. So I appreciate your participation today in the work session. The bill passes 7-4 with amendments. And with that, that'll end our voting session for the evening.
tomorrow morning.